Boy, I have other issues there.
All rise. Opening session. Circuit Judge presiding.
Please be seated. Good afternoon.
Good afternoon, Your Honor.
We're on the record for State versus Zimmerman, case number 12-CF-1083A. If counsel will please announce their appearance for the record.
Bernie Del Leon on behalf of the state of Florida.
John Guy on behalf of the state.
Mark Romero on behalf of Mr. Zimmerman.
Don West here with Mr. Zimmerman. You're seated to my left.
Mona Truitt with Mr. Zimmerman.
Good afternoon, Your Honor. Scott Ponce on behalf of the 12 media companies identified in our papers.
And Rachel Fugate on behalf of the Orlando Sentinel.
Thank you all very much. There have been several motions that were filed, and I've pulled them in the order that they were filed, but what order do you all want to proceed in all?
It might make some sense, because that could give us some indications on what else will happen if we address the media's concern over a procedure that was suggested by the state for how to handle discovery matters. So I guess we would turn it over to Mr. Ponce for his concern about a procedure if the court's considering that procedure.
Okay, I'm ready.
Good afternoon, Your Honor. Scott Ponce on behalf of the 14 media entities identified in our papers. As a housekeeping matter, as part of proper procedure, we have to move to intervene for the limited purpose of opposing the state. So we've made that motion to Your Honor, assuming you have no objection to us intervening for that purpose. The state's filing, as I understand it, wants to set up a procedure in which, if in the future defendant wants to serve subpoenas ducus tecum, they'll file a motion, which is what the rules contemplate, but they want you to enter a blanket order right now, providing that any future motion will be filed under seal, any future hearing that you might have on such a motion be held in a closed courtroom or back in chambers, and that any documents that might be produced in the future to this future subpoena be reviewed by Your Honor in camera first before they're released to the public. That turns the normal order of things and what the First Amendment says the rules are on its head. There's a presumption of openness for court hearings and a presumption of openness for court documents. And the cases provided, and we've cited them on our papers, Miami Herald Lewis is the seminal decision in this. The law provides that there's a presumption of openness, so if something wants to be closed, if someone wants to close something, the proponent of closure has the burden of coming forward and producing evidence showing why that specific issue merits either a sealed document or a closed hearing. What Your Honor can't do, what the law doesn't allow, is for you to enter a prophylactic order now saying any hearing that we might have on the future, even though we don't know what issues are going to be raised at the hearing, what specific issues will be raised at that hearing, I'm going to enter an order now closing those. And if the press wants to attend those hearings, if we ever get to that point, then they can petition for access. That's not the way it works. If in the future there's a specific motion that Mr. Amara files and that motion identifies the issues that are going to be heard at a hearing, that's the point when the state can then file a motion saying, Your Honor, here are the issues that are going to come up at this hearing. This is why we think this hearing meets the Miami Herald versus Lewis test for closure. But the law is clear, and we put this in our papers, and this is the last thing I'll say on this, is that you have to resolve these closure issues on a case-by-case, instance-by-instance basis as they come up and arise. Because until you know what the issues are, it's impossible for the proponent of closure to establish why closure is warranted. So if in the future a motion is filed and that motion says here are the XYZ issues we're going to talk about at a hearing, at that point if the state or if the defendant wants to file a motion to close that hearing, that's the time to do it. The time's not now to enter a blanket order saying that anything that happens in the future will be closed. And unless Your Honor has any questions on that issue, that's all I got.
No, thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. I guess this all results from the state filing a response, and I want to make sure the record's clear as to what we were addressing. The state filed a title, States Respond to Defendant's Notice of Production. And in terms of background, so the record is clear, the defense in this case filed 4 notices of production from non-parties for the school records of the victim in this case, Trayvon Martin. When I saw those notices, I was struck that, at least in Duval County, and I apologize, I don't practice in Seminole County other than this case, normally the procedure when somebody, that is a defense, tries to issue a subpoena ducis tecum, they have to move from the court to get approval. Unlike the state of Florida, where we have subpoena power under Chapter 27, the defense does not have that. Under the rules of discovery, 3.220, and under the case that I cited, they have to formally ask the court for authority to issue a subpoena ducis tecum. In this case, they did not. They just filed a notice saying, we're going to start issuing subpoenas. So that's why I filed my response to defendant's notice requesting that any such motions or any such attempts to issue a subpoena ducis tecum get approval from the court prior to the issuing of that subpoena ducis tecum. I believe the defense, after I filed my notice, did file a response and conceded that they're required to do that under the rules. Now, I went a little beyond that in my notice, or my response to the notice of production, because unlike any case that I've ever had in practice of over 29 years, the defense doesn't just file a motion or a notice of production. They then put it on their website so the public at large can find out what the heck is going on. And I think, quite frankly, if we're going to be able to try a case in Seminole County, which the state would like for that to happen, it's going to be impossible to pick a jury.
Now we're getting into another motion.
I apologize.
That's okay.
But
They're all intertwined to some
yes, Your Honor, I apologize. But in conclusion, and I know the court has had an opportunity to read my motion, in conclusion, what I'm requesting from the court, and that's why the media has intervened, is that in the future, and let me make sure I read it exactly as I requested, that any records obtained pursuant to the subpoenas to be issued, and I was addressing the only subpoenas that were issued at the time, which was on September 18, 2012, by defendant, be sealed and sent directly to the court, to then the court with both parties present, because we're talking about a matter that's not subject to public knowledge, that is the juvenile records of Trayvon Martin, such as similar to the defense moving when I attempted to get the medical records of the defendant. The defense filed a motion, and then the court agreed, not this court, prior judge, agreed that that would be handled in camera and reviewed by the state and by the defense, where the media wasn't present, because the defense argued that the medical records of the defendant were privileged, etc. I think the same thing should apply to the school. The defense has agreed that they're not subject to public disclosure, and they should not be. My concern is that we're going far afield in this case, in that they're not just trying not to get school records. Now they filed a new motion to get Twitter, to get other stuff. They may be entitled to it, they may be not. I know there's going to be other people that are going to object or not object to that. My concern is that it isn't just obtaining those records, it's disclosing of those records and disclosing the fact that they're trying to get those records, which the state opposes, because we shouldn't be having news conferences every time there's an attempt to get a record. That should be done by moving to petition the court for subpoena ducis tecum, notifying the state or whoever the other party is that's interested, and then the court determining, yes, you have the right to do that or not. Our position is that, quite frankly, the school records are irrelevant, but they may be entitled to get them just to go, try to find discovery. Our position is, under the law, they're not really relevant at all to this case, but I will let Mr. O'Mara make that point. The bottom line is, our position is we feel that the law should be followed in the sense the normal procedures to get approval from the court before a subpoena ducis tecum is done by the defense. And so that's all we're requiring. And then in the future, that it not be publicized on a website, so then the media gets all, oh, what's going on? I wonder what they're trying to get. And that's improper in our position.
If I might, Your Honor, as I acknowledged to the state early on, when there are records that carry with it a privacy right or a protection, a privilege, then we abide by them and always have. So when the state tried to get my client's medical records, we had that issue, and we've come up with a solution to it, and it's appropriate under the statute that makes medical records confidential. I didn't have the same opportunity when the state went and got my client's high school records, which would be confidential and protected, and I didn't know about them until they were about to acknowledge them in a discovery request that I said, please don't do that because they're confidential. I don't think he was going to disclose the records, but even just getting that out.
We're getting into a lot of different things.
Okay.
We're on the media's motion. I'd
Okay,
like to
and-
speak to that first.
Okay, I was just responding to Mr. Delaroyanda. So I think that the procedure that should be set up is exactly that. I will say that in Seminole County, in my experience of 30 years of practice, that generally speaking, the prosecutors don't object to subpoenas duces tecum for proper discoverable matters. But since he did, I did it the more formal way, and that's now before the court. So I think if we do those subpoenas duces tecum, those things which have privilege, medical records, school records, stay privileged. I should get them, as should the state, in appropriate times. And again, they got my entirety of my guy's high school records. But then we go through them, and it goes from discovery, the very large top of the funnel, to what is relevant, admissible, is the bottom. But we don't stop, we don't interfere with the process up here. As to those other records, for example, Twitter, and you'll see this in a moment, and we'll get to that motion, but Twitter, terms of use, tells you this is completely non-confidential. Matter of fact, I'll show you a case law that says the users don't even have standing to object. So with those records request, the suggestion that that should be somehow given some extra level of protection, my fear is that's the slippery slope. So what we do is we tell the defendant that we're going to limit his ability to discover information because it happens to be social media or it happens to be electronic rather than on paper. So for medical records, for school records, the statutes already give the protections the state is seeking. For those other records, unless a protection or a privilege is shown, let's do it the way we do it with every other subpoena duces tecum. We ask you, we get them, and they don't get into a courtroom until you say they're admissible.
Okay, thank you. Do you need a brief response?
Yes, ma'am, just really briefly. Because I think people are saying a lot of the same thing, maybe just different ways. And I want to bring it back to the issue as I understood we were here on.
Let me just tell you what my position
Yes, ma'am.
is, and then I'll allow you
Of
to
course.
argue if you disagree with my
Okay.
position. This is an open court. This is a public case. The court has no intention of closing the court. I know that there's a suggestion for in-camera hearings. I have no problem with doing it, but by myself. If either side wants this court to review any documents, I will go into my chambers by myself, review the documents, make my decision, come into open court, which is open to the public and the media, and make my ruling. So, if there's anything that either side wants the court to review in camera, I think there was an order entered on April 30th. It was June 30th, 2012 by Judge Lester that set forth the parameters that I think deals with this, and the court will abide by that order. So if you need to still argue, that is my ruling. It is an open court and will remain that way.
I don't, Your Honor. I don't have that order in front of me, and I'm assuming you mean the procedure with discovery stuff. Once both parties received it, there was a grace period, if that's the right word, a grace period for them to review, see if anything, they wanted to move to seal.
In the ordered and adjudged portion of the order, he sets forth the procedure that for the documents, the filing of the documents, and what's to occur. That is what this court considers to be the law of the case. It has not been reviewed. The time passed to review this order. The time has passed to review this order. So that's the order the court's going to follow. I'm very familiar with the Lewis case, and I will abide by the ruling in that case.
Thank you, Your Honor.
You're welcome. Okay, so that takes care of that motion. Next motion.
I think that dovetails pretty well into maybe my next motion, which is the motion for an order issuing subpoenas duces tecum. As to that, Your Honor, here is my position, that I think 3220, particularly the case law cited in the motion, suggests that subpoenas duces tecum should be issued for appropriate discovery. Again, discovery being wide open in our state so that we can get the information which we believe to be appropriate, either because it itself is discoverable or will lead to relevant, discoverable, and admissible information. So I am seeking, from a couple of different ways, I want to get Trayvon Martin's medical records. Now, school records. I can make part of that presentation to you right now as to the basis for it. And if you feel the need for a more focused review of why I believe I need those records, I am going to ask that you allow that portion of it to be done ex parte, because 3220H suggests that if, in fact, the court desires additional information concerning what we generally call a defense strategy or
Can I
theory.
interrupt you for just a moment? Are both sides aware of the case law of Munoz versus State, 45 Southern 3rd, 954, 3rd DCA, 2010, that also cites Dwyer, DWYER versus State, 743 Southern 2nd, 46, which is a 5th DCA case from 1999? Because I think that speaks to this issue.
I hope so, but I don't mind a little update.
Okay. Let me ask you this question. I don't read the newspaper. I don't watch the media. I'm only learning about this case, what I'm hearing in the courtroom. So are you going to be presenting a self-defense defense in this case?
Yes, we're going to have a self-defense immunity hearing at some point.
Well, it's not to do with that hearing, but I'll cite from you from the Munoz case. It says the purpose of introducing the reputation evidence in a self-defense case is to show the victim was the initial aggressor. Reputation evidence is offered to show that the victim acted in conformity with a known character trait. Because reputation evidence relates to the conduct of the victim, the defendant is not required to have had prior knowledge of the victim's reputation in the community. Citing to the Dwyer case, which is the 5th DCA case, that held that a defendant who alleges self-defense can show through the testimony of another witness that the alleged victim had a propensity for violence, thereby inferring that the alleged victim was the aggressor. A defendant's prior knowledge of the victim's reputation for violence is irrelevant because the evidence is offered to show the conduct of the victim rather than the defendant's state of mind. So based upon those two cases, I think that you're entitled to those records. I noticed in the state in their response, it said they didn't have an objection per se, so I think they have an understanding of that, the law also. But they are protected, as you had stated, as privileged documents, so you are entitled to them. So your subpoena will be issued for the school records, but you will abide by the privileges provided by the statute.
Yes, Your Honor.
Okay, so that takes care of that one, but then we go on to
Twitter and Facebook, Your
Twitter,
Honor.
Facebook, and T-Mobile.
Yes, Your Honor. And as to those, of course, similar arguments as I just made, which is that Twitter and Facebook particularly. Let me first premise this by saying any decision by this court is just the first decision that I'm going to have to go through to accomplish this. I can tell you, and there's case law that suggests this, that the handlers, the providers, Twitter and Facebook themselves interpose objections only because they don't want it to happen that every attorney can get Facebook and Twitter information. So, but I will tell you that also there's cases out there, and we'll cite them in a second, that stands for the proposition that both Twitter and, well, let's talk about Twitter first. I'll give you the case law in a second. Twitter, by the nature of, give me 1 second, Your Honor. Twitter, by nature of their terms of use, and it's identified in the case of Harris. And let me just, if I might, let me give you the case law presently so we can sort of go through it together. And I'm sorry, if you would just hand her the memorandum.
Please don't interpret this to be a criticism. It's just a suggestion. If you could provide me a memo at least the night before, so I have an opportunity to read it before I walk into the courtroom.
Yes, Your Honor.
Thank you.
I hope you know it was dated today because I finished it today. But
I read your memo of law. I haven't read the cases yet. You may
Thank you.
proceed.
And I would simply tell you that the Harris case, first of all, there are no Florida cases that address the issue of social media discovery yet. And that is quite honestly because we've just gone into the realm of electronic discovery in Florida in the past year. Don't even have it officially yet in criminal, but we all know it's coming probably by next year. So when we look at we look at sister cases like the New York case. The Harris case, very quickly, was when the New York prosecutor's office was seeking to get Twitter information on the Wall Street occupiers to see if they planned what they ended up doing. And the appellate court there, the trial court there said very specifically, first of all, look at the terms of use of Twitter, and that is an attachment to Harris, which is why I mentioned it a moment ago, and you can see that in the footnote. And in the footnote, it gives you the terms of use, which basically says, by using our service, you must understand that your tweets, Twitter events, may be viewed across the world instantaneously. And based upon that, the Harris court found that you had, not only is it not private, but you don't even have standing to come in as the tweeter to contest it. So they issued the subpoena. I will tell you that Twitter, based upon what I said a moment ago, is appealing that. That decision is due out in November from the people I know who are handling this case. And it seems as though the underlying foundation for Harris at the trial court level is going to succeed at the appellate court level because, in fact, there is no privacy. So that's Harris. And we can go forward. I don't want to do the whole memo since you've read through it, but basically we move forward to the Robinson case. What it said, it was the first time, of course, 2012, when a federal district court basically said that I see no principled reason to articulate different standards for discoverability of communications through email, text messaging, or, relevant here, social media platforms, and basically said that that information is completely discoverable. Now, as I say in Robinson, it is appropriate to at least have some understanding of what you're looking for, and I'll acknowledge that with the Twitter accounts right now. Again, going forward to the rest of the case law, it all stands for the proposition, and there's no cases that I have identified where anyone has suggested that social media is private. But for this, in the Facebook cases, Facebook is taking the position that that which was kept private on a Facebook account, because you can actually have a public wall and pages, and then you can have a private portion. Facebook is saying, well, we understand the discoverability potentially of the public issue or public matters. We will contend that the private matters were meant to be kept private and are not discoverable. I will tell you the cases are not drilled through as far as who's going to win that argument, but if we look at Harris and we look at Robinson, it would seem as though all of the case law that have addressed social media discoverability have ruled in favor of the discoverability of those because of the lack of privacy. And in effect, Facebook and Twitter is just like writing on a wall. You put something on a wall, expect people to see it. So that is as to both Facebook and Twitter. Now, I mentioned a moment ago that this is only my first step, because if you were to grant the subpoenas here today, we will then have to take on Facebook and Twitter. Now, there are other opportunities here that I hope are going to be made available to us. The reason why I have to seek getting it from Twitter and Facebook is because the family and their attorneys, the Trayvon Martin family, and their attorneys, acknowledged by Mr. Crump in a recent news release, took down the Twitter and Facebook accounts of Trayvon Martin, and it seems suggested to the other witness, who you will come to know as a witness number, a person who was on a phone with Mr. Martin at the time of the event and his death, took down those Twitter and Facebook accounts. Now, because of the nature of the internet, we have been able to grab a lot of that information. So I have a bunch of information which I believe to be this witness's tweets. It's not authenticated because it's out of a website that goes out and grabs them off the internet and brings them back into us, but I know that I have enough, if you wanted to see them, to suggest that that information could be very, very relevant to my defense. Similarly, I have Mr. Martin's tweets, or a lot of them, from the same type of a sweeping action that happens when you look at this stuff on the internet. So though I have it, it is not particularly authenticated, which is why I may need to go to Twitter. Now, if the people who suggested that it be taken down and hidden from view, they suggest because Trayvon Martin's Facebook was being hacked and they were affecting his reputation. If they saved it, as I would suggest to this court that they should have, if they kept a copy of it before taking it down, then we can simply subpoena that from the family and the family's attorneys, because presumably they would have held on to that. And that would make my job a lot easier and not delay the progress of this case. My fear is that if they have not saved it, or if they have refused to forward it upon appropriate subpoena, then I have to go all the way down the path to take on Twitter and Facebook. And unfortunately, that's not only going to be very expensive, it's going to be maybe lengthy. So, again, today I'm just asking that you look and make a decision under the case law presented, that under Harris and others, that Facebook and Twitter does not carry any level of privacy nor a level of privilege such that you would issue subpoenas so that I can go down there. Let me tell you why. It is very simple, and I know we always start with the Constitution. It is very simply a Sixth Amendment opportunity. You mentioned it with the Munoz case. The issue in this case is who did what during those couple of minutes that we don't know what happened. It is Mr. Zimmerman's strong contention that he was attacked by Trayvon Martin, had his nose broken or smashed, and had his head smashed on the ground several times while he cried out for help for 40 seconds. To date, the evidence tends to support that conclusion. Matter of fact, we have found to date no evidence that specifically counters that. Now, that's a little bit of litigating or advocating, but nonetheless, that's where we are. If, in fact, the focus is going to be on a Munoz kind of focus, was the victim the aggressor, as evidenced by the broken nose and the smash and the evidence of the injuries on the back of the head, then unfortunately, everything that he has said and done, though it sounds horrible to come before you and say, I really want to go after the victim's reputation, that is simply what the Sixth Amendment tells us we have to do in Mr. Zimmerman's defense. The state decided to say that Mr. Zimmerman acted with ill will and hatred towards Trayvon Martin. You haven't had the luxury of reviewing the probable cause affidavit yet. I encourage you to see if in that document there's any evidence of ill will or hatred. And as we go through the rest of this discovery, you may become more aware of whether or not it's there. But since that is now the standard, since they have to prove that my client acted with ill will and hatred towards Mr. Martin, how Mr. Martin acted is utterly relevant. It is, in effect, the primary issue of this case. And what he said on Twitter, and what he said in his Facebook, and pictures he put on his Facebook, some of which I can show you if you wanted to see them, and his behavior, what videos are out there on the internet of MMA-style fighting, all of that information is going to become relevant in this case. That's for a later day. It is certainly discoverable at the top of that funnel for right now. And what I'm saying is let me continue to get started. We have a lot of other motions here today evidencing my frustration with discovery to date.
I don't need that argument right now. I understand your argument.
Last comments that were made, I don't mean to argue the case in front of this court, but I respectfully disagree with the argument made, because we're not here right now to litigate the case. And Mr. O'Mara, because the media is here, for whatever reason felt the need to do that, I respectfully disagree with his assessment of what the facts are.
We don't need this going back and forth against each
Thank
other.
you, Your Honor.
We'll stop now.
Yes, yes, Your Honor. Regarding the issue before the court, that is, in terms of the Twitter account, let them have it. Let them go at it. They can argue with Twitter whether they're entitled to it. Now, I'm going to argue they're irrelevant, but we're not at that stage now. Now, I disagree with the defense, and in terms of their actual motions, and I don't know if the court has before it the motion, and I don't know if we've gotten to that stage, because there are a bunch of motions in front of the court.
You'll learn that as far as being organized, I'm a little anal, and I have every motion, every response in a different folder. So just tell me what it is you want. But right now, I'm concentrating on the Twitter and Facebook account. So if I understand you correctly, you have no objection to the defense having those subpoenas issued, and then we'll have a later hearing if and when Twitter and Facebook decide to respond.
That is correct, Your Honor, regarding the Trayvon Martin. And the reason I asked in terms of what motions before the court, because one of their motions is motion for order issuing subpoena ducis tecum, which includes other people other than Trayvon Martin.
They have Mr. Martin's Twitter and Facebook account and witnesses. So we'll just say right now, so the clerk can get this down in her minutes, that the Mr. Martin's Twitter and Mr. Martin's Facebook account, the subpoenas will issue, and the court will entertain any motions filed on behalf of Twitter or Facebook in regard to that. Now you wanted to speak about the witnesses.
That is correct. Our position is that there has not been a showing, and the reason I say that is because I only have the motion, and then there's something in the motion as to like paragraph E where paragraph F, where they cite the witnesses and they've redacted, because it's stated here, state's witness name, redacted. Further information required will be disclosed on the face of the subpoena. I never got the subpoena or the proposed subpoena, so I haven't seen it. But
Okay, do you have a copy of it now to show, Mr. Delaranda?
No, and here's why. Because she's a juvenile, and I want to be very careful. Twitter is going to have to know who she is. I want to be very cautious. We have an order right now that still maintains her name confidential. I want to keep that confidential as long as possible, but I will tell you that when I issue a subpoena, when you sign,
Well, but
Twitter's
you can tell what it is that you're seeking without telling us that person's name.
Sure.
So what is it that you're seeking, because he's not aware of it?
The entirety of her Twitter account
Okay?
that Twitter has available to it.
Facebook?
And Facebook, yes.
and our position is that they should be entitled to it. They haven't established a relevancy or even an opportunity to why they need it, other than, I guess, the argument that was made today, but I don't know that they've tied it in terms of this particular case as to the relevance or even entitled to even explore it.
Shall I?
Yes, you respond to that.
Two examples. We know that a person, the juvenile, was identified some weeks later as a witness who may have been on the phone with Mr. Martin at or just prior to the event of his death. And we know, because I have the evidence here from the internet but not from Twitter, that she is an active tweeter. She has suggested, it's been suggested to us, and it was sort of apparent on the internet for what that's worth, that she was so devastated by the event of Mr. Martin's passing the night that she found out about it that she did certain things. Couldn't go here, maybe didn't go to school or whatever. And similarly, that she did not attend a service for Mr. Martin because of being overwhelmed with the significance of his passing. What I've seen online, presuming them to be accurate at this point without knowing, without authenticating them, contests those suggestions. So, if, for example, I were to say to you, I have a migraine headache today, and all of a sudden you see on my tweets that I'm out at the mall, or I'm out at McDonald's, or that I'm out shopping, or that I'm at a football game watching loud noises at night, which would kill me with my
What
migraine.
you're saying is for impeachment purposes.
Absolutely.
Okay.
And so, but I thought we needed more relevance than that.
Yes. The evidence that Mr. O'Mara cites, they haven't proven that that actual person said that or tweeted that or whatever word you want to use to describe what they did. That is pure speculation. I don't know that the witness identified herself or somebody was using it in her behalf. So there's been no connection in terms of actually establishing. It's not like impeachment, like a witness, you've got a statement or something where it's clear that that's the person that uttered that statement. What we're going on, and Mr. O'Mara's words were suggested. apparent, but there's been no proof represented to the court, and I haven't been provided with any proof that shows that this witness tweeted, or whatever words is used to describe when someone does that such a thing. And I apologize, I don't know what that, I know what it is, but I don't know what words are used to describe what the person has said, other than writing it or whatever, or typing it in. So there has not been a connection at this point that that person actually did that. There's reference and by Mr. O'Mara that the person is a juvenile. Has that been proven? Is that accurate? I know who the person is, and I cited the person, but we're going far afield here speculating, with all due respect to Mr. O'Mara, as to who the person is. He knows the name because I disclosed the name, but there's been an indication here she's a juvenile. Have they proven that?
I just have to respond by saying, in good Lord's name, if she's not a juvenile, then why is he kept telling me she's a juvenile who needs to have her name protected? I'm sorry, but here's my last response, Your Honor. The state does, in fact, have enormous subpoena authorities well beyond mine, as they mentioned in their opening statement. This is one of their primary witnesses.
Okay, you can stop right now. Okay. I'm going to do the same ruling as to that particular Twitter account as I did to the Facebook, and it will be as the Twitter and the Facebook for that individual. Again, any privileges that are afforded under the statute will be abided by. And Twitter and Facebook want to come in and make their motions, that's fine. What about T-Mobile? You wanted T-Mobile for Mr. Martin and T-Mobile for the same individual witness?
Yes, Your Honor.
Same arguments?
Yes, Your Honor.
State?
I have no objection regarding the phone records. Those have actually been provided, but if they want to request them on their own, that's fine.
Okay, those motions have not been objected to. Those requests, they will be granted. Again, of course, any privilege will be abided by. So that takes care of the defense request for the different subpoena duplice tecums. On to the next one. I have them in an order, if this is okay, if you're ready to argue them in this order. The next one will be the state's request for a subpoena duplice tecum for the Altamont family practice. Are you ready to argue that one?
Yes, Your Honor.
Okay.
The bottom line, and I know the court has had an opportunity to read our motion, is we feel this is very relevant under our subpoena power in terms of finding out exactly what the proof is or lack thereof, because there's been allegations that the defendant has a broken nose. I have seen no proof of it, but there's been an allegation other than somebody said you may have a broken nose. A medical technician said you may. We've deposed those people. We've interviewed those people. They don't say that he had a broken nose. The medical records that I see indicate that he may have a broken nose, but there's no x-rays. There's nothing to indicate that actually he had that. There's no evidence consistent with the defendant's allegation that his head was bashed into the concrete. There's no concussion. There's also evidence in the medical records that I've received, which is limited, that somehow he's taken medication. That is very relevant to our case to disprove his story. And so we feel we should be entitled to look at that and receive that and produce to show the lack of in a lot of cases.
Okay, thank you. Response?
Yes, Your Honor. Medical records obviously come before you with one of the highest levels of privilege. I would have no objection to a limited release to the state. And I actually thought...
Well, what are you thinking is limited?
30 days before, 30 days after. I was just thinking that that'll show the medicines that he was on, and I'm not posturing here, that'll show the medicines that he was on prior to the event, and 30 days afterwards will show the treatment he got for the injury sustained. Now,
First I thought you meant 30.
All the records that are there from the place. I don't know what there are. There may be only for 30 days. There may be, I don't know until I get them in terms of whether the relevance is. I'm not saying that they would be admissible or not admissible. We should be entitled to look at them to establish how long he'd been taking the medication, what impact, if anything, it had on him, and the lack thereof that 60 days later or 6 months later he went back and got some treatment which refutes that he did allegedly have some kind of injury to his nose.
Okay.
then this may be the best way to handle it. We would acknowledge that they get medical records. I think 30 days before and 30 days after the event is appropriate. I think anything more than that unnecessarily violates my client's right to privacy, which he still does maintain of a medical records.
Would you agree to that same thing if I said Twitter and Facebook 30 days prior to and 30 days after?
Probably 6 months, because that's much more relevant. the events, and quite honestly, if you look at what the issue of what it is that we are trying to get accomplished here, reputation, which is what Twitter and Facebook is going to show.
Okay, but this is discovery, and it needs to lead to admissible evidence or the discovery of admissible evidence. And medical records are protected. They're afforded that same privilege as the school records are. So whether any of this stuff is actually admissible in court is for another time.
Right.
But whether they're entitled to them is a different issue. So what were you going to say?
Pursuant to the judge's ruling, Judge Lester, what he was going to do and what he asked for was that we provide the court a sealed copy of the entirety of the medical records
From Altamont.
From Altamont family. So I have a full copy because I'm allowed to as his lawyer. This is the copy. I would simply ask that at a break that you review with my thought in mind of a limited 30 days.
Break today or break over the weekend?
A break over the weekend.
Thank you, that's a lot better. Okay, so I'm going to go ahead and reserve as to the medical records are, the request for medical records is granted. The representation from the defense is that what they've handed me in court today is all of the medical records of Altamont Family Practice. I will review them in camera myself. I will issue an order as to which of these are to be produced and not. I'll try to set forth some kind of a log that will show which ones that there are. If there are any that are not being produced, I'll identify them by a certain way so we can have a hearing about that at a later time. Is that acceptable to both sides?
It is, Your Honor.
I apologize for the court in terms of addressing this issue, but I guess the representation is being made by Mr. O'Mara that is the complete medical history as to that particular, which is what the subpoena stated. And so without looking at them, I can't tell. I know the court's going to review them, but I want to make sure that that's a complete record of everything there in that facility.
That's my understanding of the representation.
And two things. I think the first page on the inside acknowledges that it includes a complete, and I have the letter that I received saying that it is complete. So you will have that by the end of the hearing, which is the cover letter that I got with the sealed envelope. But I think the first page inside was also to be a copy of the letter saying this is everything.
Okay, so the production of medical records is going to be granted, which, if any or all of these, I will issue in an order and make them available.
And may I just inquire of the court regarding I understand the court, but that was due to Judge Lester previously had ruled on that. Now the court, which obviously has now before it the school records, has made a different decision regarding the school records. I would suggest to the court that that same should apply. The medical records should be treated the same as the school records. In other words, the state should be allowed to get it, because what we were requesting of the school records is the same thing, that they appear in front of the court.
When it was requested in the school records, you said you had no objection that they were entitled to it, so that's why I didn't make any ruling on that.
I apologize. I'm talking about my original motion regarding the media intervention in terms of that all the records be submitted to the court and the court make a determination.
You were talking about, my understanding was you were talking about any future subpoenas.
I apologize. I maybe was not clear as to that.
Like the medical records, the school records are privileged, and they're based upon the privilege. I have no idea what's in here. I will make my ruling after I review that. So I think that takes care of the request for the Altamont Family Practice. The next one I have is the defendant's request regarding witness number 9. What I have that was provided to me from Judge Lester, he gave me a big bag of a whole bunch of, I don't know if they call these CDs or DVDs, but you know what I'm talking about. Okay. And I have 2 for witness number 9.
Here's the concern.
Well, instead of going into this whole big thing, is there any objections? I have no need for this, for me to give to the defense exactly what was given to the court, so there is no question of what mine says as opposed to what theirs says.
Are you certain? I just have to ask because the existence of a third CD is...
I don't have a third CD.
Okay.
Being as organized as I am, I put in order in little bag manila folders each, a group of witnesses and each group of everything that was provided to the court. It's under lock and key.
Yes, sure.
I have brought in witness number 9. This is all I have.
That's fine.
You don't want them?
No, I mean, that's fine. We will take
Does
them.
the state have any objections to it?
I'd like to be able to make sure that I can review them too. I know what they are, but I don't want there to be a representation that's not what it is. So I'd like to be able to, at the same time,
Well, what we
both
could do, you
sides.
have computers here when I
Right.
leave. You could do that.
That would be great.
Sounds great.
To be reviewed by both of you before you take it home with you.
Yes, Your Honor.
Thank you, Your Honor.
Does that take care of that motion?
It does, Your Honor. Thank you.
Okay, thank you. The next motion is defendant's request for FDLE file, FBI file, and DOJ file. Give you a moment to get there.
Thank you, Your Honor. I'll be honest with you, I'm not certain this is right because it's a demand and not a motion to compel for failure, but I'm glad that we can address it real quickly. The frustration that I have, Your Honor, is that we are 4 or 5 months into the discovery process here. And as can be seen, because if you've reviewed the other motion, there are a lot of issues that we're concerned about with the disclosure of information. Let me give you an example. The FBI has gotten involved in this case and have been involved in the case for at least 4 months that I'm aware of. And what we have received from the state, from the FBI, is 54 pages. Knowing the FBI as I do, having had other investigation efforts with them, I would suggest to the court that they would produce 54 pages of documents if somebody littered in front of a federal courthouse.
Okay, I don't need to go on with that.
Well, my frustration is I'm 4 months into a discovery process. I have a governmental agency who's telling me they only have 54 pages.
Has the FBI been subpoenaed to come here so at least they could respond to what they have or do not have?
Well, again, it's a demand that's out there to the state because under Brady and the other paperwork, other case law that we'll get to, what I'm asking right now, this is a specific demand to the state, not to the FDA, not necessarily, or not yet to the FBI.
And your demand was filed on October 11th, 2012, and I may have been overzealous in my trying to get everything here in the hearing today, and that's really not at issue today. The state has an opportunity to respond in writing and object if they feel they need to. So let's take that off the table for today.
Yes, ma'am.
And if we need to hear it at another time, we'll have the time to do that.
Certainly, thanks.
Okay, I'll keep that over there. Defendant's motion to compel regarding color copies, photos, addresses, original interview of witness number 8.
Thank you, Your Honor. Don West on behalf of Mr. Zimmerman for this motion. There are 4 discrete areas set forth in the motion for which we are seeking an order by the court directing the state to produce this information. This is as a result of failed attempts to get this information over a period of weeks and to some extent months. I can represent to the court that in paragraph number 1, the digital original format color photos of cell phone photos taken by witness 13 have now been provided.
Okay, so that's not an issue anymore, correct?
Yes, we got those yesterday afternoon, these pictures, but have never received our requested digital copies so that we can enhance or show it to witnesses or send it to experts or have it in the same form that the state got it in its investigation.
Okay, let me
That's
have the
critically
state
important
respond.
during depositions and such.
Okay, have the state respond as each one as we go so we can keep them on.
Your Honor, as to number 2, we have provided what we have, which is Mr. West is correct. I originally just gave him the black and white. He requested a color, and I provided a copy. We only have the color copy of it. We don't have the digital. I told Mr. West that I would try to get it. In fact, actually, that witness was deposed yesterday. I don't believe the witness was asked about it, but I don't believe they asked him, is it still on your phone? Or anything regarding that, because the witness himself, Officer Wagner, actually used his personal phone to take those photographs. So there was an opportunity to ask the witness, and I apologize, maybe Mr. West has a better recollection of what the witness said. I will still try to get it from the investigator, but as far as we know, all we have is what we gave him. That is the color photo. I will attempt to get a digital, which is what Mr. West has requested, but I'm not aware of that existing, but I will try again.
Was ever created.
That is correct. I know that the Officer Wagner emailed Investigator Sereno the photographs, and if by email maybe that means a digital, maybe that's correct. There is something there, but I was only given by the Sanford Police Department detective lead detective a color photograph of it in terms of the actual hard copy.
Right, Mr. West, would it help you if you got an email like Detective Cerrito got? If that's all that was created, would that help you for your purposes?
In the discovery provided by the state on that topic, we received a PDF copy of a printed email from Officer Wagner to Investigator Serino saying, I heard you didn't have these pictures. I took them on my cell phone. Here they are.
And they were attached?
They were attached as JPEG files. We have never gotten the JPEG files, and that's what we've been after for weeks and weeks and weeks.
Does the state have those from the email?
We got an actual email that had the attached copies already on there.
Can you
So,
send those to the defense?
I already gave it to them. I actually got a physical, the actual copy in terms of the email printed out. I don't know if I'm addressing the court.
No, I'm asking, like, can you email from your office to their office forwarding that email that you received?
We did not get the email. We got a printed version of the email that had the colored photos. I will attempt again to get the actual email if it exists, and I will provide that. But I never got the actual email if I'm addressing the court.
Well, maybe Detective Serino is the person who has that email and can forward them on. So if the state could try to get
Sure.
that and forward it on to the defense.
Yes, clearly he got the email. Unless it's been destroyed, then it has to exist.
Well, that's another issue we may have to address at a later time.
I know, Judge, I don't mean to be frustrated, except that now we're here after so many failed attempts to get something.
They can't give you that which they do not have.
Their
So-
obligation, Your Honor, is to go get it, if it's in the possession and custody of one of their
They
agents.
don't know yet whether or not it exists. So that's what Mr. De La Ronda is saying. We're going to find out if it exists. If it exists, we will forward it on. If it doesn't exist, it existed at one time and doesn't exist now, that may pose a different issue that we would have to hear at a later time.
Yes, Your Honor.
Okay. So then number 3,
In the state's various discovery exhibits, a number of witnesses, 7 or 8 of them, did not include addresses. It included only that they should be contacted in care of the state attorney's office. I have also failed in my requests to obtain their addresses informally. I have been told by Mr. De La Ronda that he will not provide those addresses since now I filed the motion asking the court to rule on the issue. I cited Rule 3.220, which requires the state to provide addresses as well as the names of its witnesses. I've also cited a 5th DCA opinion, Holmes v. State, which in all intents and purposes says the same thing, that absent some extraordinary circumstance and exception, which we do not have here, the state's required to provide the address of the witness. What I don't know, because we haven't yet gotten there, is whether if I were to have deposed or attempted to depose these witnesses and they were provided or produced pursuant to Mr. De La Ronda's suggestion that he would have the witnesses come, whether he would direct them not to answer my questions about their address or something else. We never got there because the state has an obligation to give us the addresses as part of its discovery obligation.
response?
Yes, Your Honor. Regarding the particular witnesses that Mr. West filed the motion on, they're quite frankly, family members are very, I guess, not to overstate it, but threatened witnesses that the state is concerned regarding their safety. As I indicated to Mr. West, I will produce those witnesses, guarantee that they will appear in deposition. I believe in the deposition, since it's not for public consumption in terms of disclosure, depositions are normally not published. They don't, the press cannot be present for a deposition. Then Mr. West can inquire of the witnesses the address if he feels the need to. But to just disclose it, I am concerned for these witnesses' safety, Your Honor. I've taken to the extreme in terms of certain witnesses, such as the defendant's father. I never listed an address for the defendant's father or for other relatives of the defendant. I always listed them just their name on purpose. But the state is concerned regarding the victim's mother, the victim's father, the victim's brother, and the other witness that we spoke of that was having a conversation with the victim. Their safety is at stake, Your Honor. This is there's been a lot of stuff about threats, et cetera. Well, that also applies to the victim's family, and the state is concerned about their safety. I will produce them there for the deposition, so there won't be an issue about them not being subpoenaed. I've indicated throughout this case, I will bring witnesses in without being subpoenaed. I will make sure that they appear. I'm not talking about just these witnesses, other witnesses. But at some point, the safety and concern of these particular witnesses is paramount to this case in the sense of their safety. And so I don't understand why they have to have the addresses of the victim's mother, the victim's father, the victim's brother, and such people. And so we object. We don't, I understand the rules normally, and we do provide the addresses, but I don't know.
Judge Lester entered an order on April 30th, 2012 that addressed this issue, and in its findings, paragraph 5, he wrote that documents containing the defendant's current address or location will remain under seal, as will any document reflecting security procedures to be employed on behalf of the parties, attorneys, and witnesses while at the courthouse. And in the ordered section, he says, paragraph 2, all documents filed with the clerk of the court shall remain open for public inspection with the exception of A, documents addressing the security of the parties, witnesses, or attorneys while at the courthouse, and he went on to other documents. So this has already been addressed. It'll only become an issue if and when these people are not, do not show up for, you want to respond?
I do. I'm sorry, was the court about to rule? Because I think there are other issues that are part of this.
Go ahead.
As the court's aware, there have been redacted witness lists filed identifying witnesses only by number even, much less without an address. There are procedures already in place to protect such things as addresses and even the identity of witnesses from the public. That's not what we're talking about here. I've asked Mr. De La Ronda and asking the court today for us to have those addresses, not just so we can issue subpoenas for deposition. In fact, we probably will take him up on his offer to produce the witnesses. But there are other reasons why we want to know where the witnesses live, for investigation in the case, to understand lots of different aspects of the case beyond simply physically where they live. The safety issue is only that as it relates to Mr. Zimmerman being a threat to these witnesses. That's the only issue that the case law supports as a reason why the address should not be provided. Not a general global threat for people who have been very, very public over the last several months. The Holmes case talks about that, as do the cases cited in it. In fact, Your Honor, because this has been going for some period, on August 23rd, I wrote an email to Mr. De La Ronda about this issue, and I said, I'm not opposed to maintaining their privacy with the public. I'm not asking you to file a discovery response with their addresses. You can file a sealed pleading or just give them to us, and we will keep the information confidential, as we have with all of the other witnesses whose real addresses and real names that we know. Getting no response, and wrestling with, only 4 of which have actually found its way into this particular motion for today. Again, I want you to provide us with their actual addresses so we can conduct our own investigation. I'm not opposed to maintaining the privacy, not asking you to file a discovery response, file a sealed pleading, or just give us the names and we'll keep them private. Judge Lester's order we submit addresses how witnesses' identities, those that are to be protected from public scrutiny, is to be maintained. And it's worked very, very well so far. The rule requires it and the case law requires it, and we submit that there is already a procedure in place. We don't have to do anything differently than we've already done.
Any response from the state?
No, Your Honor, I believe I've already made my argument.
Judge Lester's order will remain in full force and effect, and that's the order of April 27th, 2012. But I will say this, when you issue a subpoena, the person who goes out to serve the subpoena knows that address and can reveal that to anybody they want to. So what this court's order is going to be that the state will produce those individuals for depositions when you require them. You may ask them at their deposition what their address is. If they refuse to answer it, the state's not to instruct any witness that they cannot give their address. But if they refuse to give it, the court will take that up at a later time.
With all respect, Your Honor, I understand the court's ruling. However, the court's ruling doesn't contemplate how that affects our ability to effectively and completely prepare for deposition. That's part of the process, is understanding the context and the environment in which the witnesses...
The particular address of where a person lives shouldn't interfere with your ability to take their deposition.
But it very much does, because it's understanding the environment, identifying neighbors perhaps, people that know them, a way to investigate the context of their lives, which is very relevant and I think necessary before they are in effect blindly sat down in a room with us being expected to have been prepared when we've been denied the tools to do that.
The state will produce, the ruling will stand, the state will produce those witnesses for deposition when it's coordinated with both sides, and you may ask them what their address is, and the state is not to instruct them to refuse to answer that question.
Would the court then entertain a motion at the end of those depositions to allow us leave to investigate what we've learned at the deposition, and then...
The court will always entertain any motions that are filed.
That would be to then suspend the deposition and then continue with it at a later date.
That may not be necessary, so I'm not going to issue an order about that, but if there's something that occurs that people feel they need to file a motion, the court will entertain those motions.
Thank you.
Thank you. Then we have the defense motion to schedule hearings and the state's response. I have read the motion.
I'm sorry, Your Honor, there's one more aspect of the motion to compel.
Oh, I'm sorry, there is, and I apologize. And that would be paragraph number 4.
Yes. A bit of the history on this for context is that witness 8 is the person that was previously described as having been on the phone with Mr. Martin around the time of these events on February 26th. Her name was unknown until several weeks after the event, apparently unknown to law enforcement and unknown to the state attorney's office. We don't have any information about that other than somewhere around late March, she was interviewed, and it was recorded. At least one person involved in the interview was Mr. Crump, the Martin family attorney. And there were clearly others in the room as well. You can hear some other voices in the background, plus shortly after this interview took place, there were media accounts where ABC News claimed to have an exclusive copy or exclusive access to this interview. When we inquired further informally about this, I guess it was specifically on August 23rd, August 24th, following a hearing that we had here. I asked about that and was told that the state did not get that recording from Mr. Crump, that the investigator believed that it came via the FBI or via the Department of Justice. We'd not heard that before. There are no reports discussing it, nor have any of the witnesses present when the recording was made disclosed. We don't know what led up to it or what happened after it, other than there was a media broadcast about it. So I then followed up and said, well, tell us more about it. And by the way, we can't understand hardly any part of it. It's largely unintelligible. I asked, was it digital? Was it analog? What can we do to get a better copy? And no response. No response. So following that up again in writing.
Of the witness 8, number 8 interview with Mr. Crump, including, as you say in here, the names of people present during the interview and the chain of custody of the recording.
That would be a good start. We just don't know anything about it. But again, the frustration is that we're here only after several failed attempts to
The
get
disparaging
here.
remarks going on both sides, I said, again, are going to stop. I just want to know what the basis of the motions are. So do you have more argument? If not, I'll get the response from the state. You'll have an opportunity to rebut.
I'm sorry, I don't intend to disparage anyone. Providing context is only that's why we're here. with a motion to compel rather than
I
something
understand the reason
informal.
that we're here on any issues is because they were not agreed upon, and that happens often.
Very good.
In all cases, so it's my intent to get through these.
Thank you.
Thank you. Mr. De La Ronda?
Your Honor, we disagree. I'm not going to get into it in terms of commenting about what Mr. West stated, but the recording, as I understand, is actually by phone. So the recording by Mr. Crump of this witness is by telephone. That is, Mr. Crump was not present when the witness gave this interview or recorded statement to Mr. Crump. And therefore, we provided the best copy we have, which is what we got. I don't know how to get a better copy. I got the best copy that what I understood was the exact copy of the document itself in terms of recording. And I've turned that over, and I've told that to Mr. West. But
Do you know who else was present during the interview?
there are other people that appear to be present in terms of just by background noise, but I would have to ask Mr. Crump in terms of who, because my obligation is what I was trying to find out is there a recording of that witness, get it, which I got, and turned it over to the defense in terms of, since it was not in person, in other words,
Who created the recording you got?
Mr. Crump.
Okay. I guess we need to find out from Mr. Crump whether or not he saved that on his phone, and if he saved it on his phone, if there's a means to get that, a better recording of it.
He's in the courtroom.
And he's in the courtroom, so.
Well, I'm not
we
going to
can-
put him on the spot, but if you want to ask him, I'll sit here and wait.
Mr. Crump is willing to talk and tell the court exactly where there is, so there's no dispute
Mr.
about
Crump,
it.
if you'll please come up to the podium, please, sir.
Yes, ma'am, Your Honor.
And you've been able to hear, we're discussing the alleged recorded interview of witness number 8 that you made. Could you please tell us how this came about? What process did you use, or what means did you use to record it? And if you still have that recording on your phone?
Yes, ma'am, Your Honor. It was recorded by telephone. We got the information to the FBI, who had the most sophisticated recording devices, I guess, in the United States. And that recording was then preserved by them and given to the state of Florida. It was very hard to hear because it was on the telephone. We were trying to hear clearly the recording on the telephone, but it was difficult to hear. And there were people in the room, and I have told the state of Florida anything that they will require of us, of Trayvon's family, we will absolutely cooperate in any way, fashion, or form. I understand we're going to be asked questions and deposition about the issue. We're ready to go at great length to give the court and officers of the court anything at all they
Let me
want.
interrupt you for 1 minute. The people who were in the room, did you have it on speakerphone?
Yes.
Okay, so we're going to need a list of the...
Check.
If you would please, is this deposition set?
No, but maybe we can get the list of the people who are in the rooms now so we can put them on our witness
You may
list.
not have them now, but I'll give you 10 days to provide that list to the state and the defense. But I'm going to ask, if it is on your phone, please do not erase it. And if it is on your phone, if you would bring it to you to the deposition so the attorneys will have an opportunity to listen to it at that time.
Absolutely, Your Honor, and the family has been willing to participate in any way that the court will have them.
Does that take care of that?
Not quite.
Okay.
Not quite, Judge.
Don't
May
move
I
yet.
make some inquiry here?
Yes, you may.
Mr. Crump, you mentioned the FBI. Was the FBI involved in making this recording?
No, sir.
And what do you mean by the FBI having sophisticated recording equipment?
Sir.
Those are questions that could be asked at a deposition. So
Mr.
he's
Crump's
ordered-
not on the witness list, Judge.
Well, he said he's ready to give a deposition. so
I know
he's-
that, but he's not on the witness list. The state has not offered Mr. Crump as a person who knows something about
The
this
court's
case.
going to make him a witness for the purpose of taking a deposition regarding this issue. So you can take his deposition,
Thank you, Judge. We'll schedule that as soon as we're able.
okay? And
There-
if you will please bring your phone, just that, the phone, if the attorneys wish to hear it at the deposition, they may do so together at that time.
A couple.
Okay, I will certainly check it.
A couple of follow-ups, if
Go
I might,
ahead.
for clarification. Mr. Crump is still directed to provide the names of the persons.
Within 10 days.
Yes, and also the circumstances under which the recording was released to the media, and the circumstances under which it was provided to the FBI, if in fact it was. I'm not quite clear. Is that what happened? After you recorded the
Okay,
phone?
that will be taken up in a deposition. You know, if you're not able to get whatever answers you want in a deposition, then you can let me know. But I don't want to take up our time here today deposing Mr. Crump. First of all, he's not under oath. So you can ask him those questions. I'm allowing you the opportunity within 10 days to have the names of the people who were in the room that could hear both sides of the conversation, because it was on speakerphone, and providing you the opportunity to listen to that interview from his phone in a room with Mr. De La Ronda or whoever the state.
Would the court inquire of how the state came to be in possession of the tape? Because Mr. De La Ronda didn't claim any source whatsoever, only that it showed up somewhere.
Those are questions that you can ask, and I'm not taking Mr. Crump's deposition here in the courtroom today.
I can't take Mr. De La Ronda's depo, at least not yet. I'd ask the court to inquire of him so we can further this discovery. How did he get the tape? Who did he get it from? What's the chain of custody?
Okay. Mr. De La Ronda, who did you get the tape from?
I got it from FDLE, who got it from the FBI, and I've already indicated that to Mr. West. But again, I'm not going to get into a banter here in terms of attacking us. I'm abiding by the court's order in terms of not getting into a
Who got it
dispute.
from the FDLE, who got it from the FBI, who got it from Mr. Crump. There you go.
Thank you, Your Honor.
Thank you very much, Mr. Crump.
Yes,
Is there
ma'am.
anything else in your motion to compel discovery that I can assist you with at this time?
No, Your Honor, thank you.
Okay, thank you very much. Then you have the defense motion to schedule hearings and the state's response thereto. In order to assist you, if you have your calendars available, I have available dates and times through the end of this year, and can go into January now if we need to, that we can go ahead and schedule the hearings, keep it on there. If the hearings are not necessary, you could call my judicial assistant beforehand and cancel it, but at least we have them and we know if any issues come up. Do you all have calendars?
We do.
Okay, all the hearings are going to have to be in this courtroom, so I have to coordinate them with another judge's schedule. But what I've been able to glean from both my calendar and the other judges, I have October 22nd at 9 a.m.
Is this for any particular length of time?
You tell me how much time you want me to set aside, and then we can release it, if you're not going to use it.
We would request a 2-hour block, although I can't represent today that next week we'll have 2 hours. We may.
Right, and if you don't, you'll call me and say it's only going to be an hour, or it's going to take the 2 hours, or we don't need any time.
Very good, yes.
But I will block those off until the release. Is October 22nd at 9 a.m. work for the state?
October 22nd is fine with the state, but unless a motion is filed this afternoon, I mean, that's Monday coming up. We don't mind driving here Monday, but no motions that are before this court now.
Well, if you don't want a hearing time in October for future motions, that's fine with me. But I also have November and December dates too. So do you want to wait until November?
Could do that.
Your Honor, to that issue, if I might,
Yes.
I am going to at least outline for the court an issue that I was going to ask you to address today in an emergency capacity, but now maybe we can do it on Monday. And that is an emergency motion for protective order. And again, the state's just been handling it, so it may be better to hand this on Monday, but I want to give you the idea.
Today's Thursday. I don't know if that's sufficient time for them, but we'll find out.
But the emergency nature of it may make immediate relief necessary, and may not prejudice the state. As you can see in the body of the motion, we had taken depositions yesterday, and one deposition that we took was from a Sergeant Son.
I don't want to hear this motion until the states have an opportunity to at least read it.
Okay.
I haven't even read it, so why don't we take this up after, just give us a chance, have a seat, let us read it.
Okay.
The state may not have any objection to it, or we'll find
But
out.
I do think that the emergency nature of it does need to be addressed today, Your Honor.
Okay, let me read it, please. Have you had an opportunity to read this?
Very briefly, Your Honor, and quite frankly, there's several issues. I'd like to address this, if we could, after we deal with the issue of the gag order and other issues before the court, because this is a deposition of the witness. There are other witnesses that, well, at least one of them was deposed yesterday that I will submit contradicts, or at least has a different take on what occurred here in terms of what's doing, and what the defense is doing in here is trying to leak out certain parts of the deposition that is taken of a witness. This witness never stated this in any police report or anything, so to imply in some way that this was Brady material that the state was aware of is improper and unrealistic. So and number one, and number two is I've just been handed this all of a sudden, and so I would object to it. I would object to the filing of this motion, and to it. An opportunity is allowed for us to address this whole issue in the entire context of which is stated.
Well, the motion, and I understand what you're saying, the motion was handed to this court in open court. Any party can go to the clerk's office and file any motion. It's deemed to be filed because it was handed to me in open court. I have an original signature, so
Yes,
I will give it to the clerk to file it. But as far as doing the argument on the case, I will provide the state an opportunity to review it more than the few minutes here in court.
Yes, Your Honor.
I don't see any legal authority for what you're requesting, and I would like the opportunity to go back and look at it because I've never had this request come up before to sequester the witnesses that before their deposition, and that the attorneys not be allowed to talk to them. As you well know, in trial, when the motion for sequestration is granted, the attorneys are told, and I will tell the witnesses, you're not to discuss your testimony with anybody else except for the lawyers until you're finished, the case is finished. And I need some authority of why I should go beyond that. So.
And let me just tell you the relief that we're seeking, because I think the relief is fairly minor. This came up yesterday, where an amount of, excuse me,
I'm not hearing argument on this right now.
I was just going to tell you the relief. I wasn't going to do the arguing.
I read your motion. I understand the relief you're asking. Let's get back onto my thing about the scheduling.
Yes, ma'am. Quick question, just to head something off at the pass, and tons of phone calls that are going to go to your chambers as soon as we're done. Will members of the media be able to grab a copy of the motion that has now been filed as soon as the hearing is finished? And is there a procedure?
First of all, just so the media knows right now, anytime you're going to call my office, you're going to be referred to Michelle Kennedy.
Yes,
so you'll save yourself one step if you just call her.
Yes, ma'am.
As soon as the clerk inputs that into the computer, or Sarah can tell you what she does with it since I've handed it to her, and you can make arrangements with
yes,
Sarah to do
we'll
that.
We'll talk to Michelle afterwards to try to figure out the best way to do it.
Okay,
thank you,
thank you. All right, back on the schedule. Monday may be, since you're traveling from out of town, I could do it, a telephone hearing. I could come into the courtroom and you can appear by phone and argue that.
What I would request regarding is an opportunity to respond in writing.
Okay.
And I would request that the court seal the document until the state has an opportunity to respond. I think the court has the right to seal it because what it is just basically one take of something that happened and it's taken out of context. With all due respect, this has just been thrown at us right now, which is, I guess, allowed under the rules. I mean, that can be done. So I would like to have an opportunity to respond in writing. The court has the authority to seal it until the state responds, and then the court at that time, at a hearing, can release everything and there's no issue about it.
Your Honor, this is the sworn testimony of a state witness. So what they're saying, in effect, is that because I didn't like what the state witness said in his sworn deposition yesterday, where he uncovered a bunch of information I won't argue to you, but is in my motion, that he somehow now thinks that that information, sworn as it was, and maybe opposing to the state's position in the case suggesting second-degree murder, should be sealed.
Is there any problem with what the state suggests, that as soon as they file their response, that both documents will be released?
If you would offer me this, the relief I'm seeking is just that nobody talk to the witnesses until we depose them. So all I'm asking is...
I understand what you're asking.
That's not much.
I even stated it on the record, and it may not be much, but that's something that I need authority for doing that, because like I said, in trial, the witnesses are not to discuss their testimony with each other or anybody else but the lawyers. So now you're asking me to restrict the lawyers, which would be either side, from having any conversations with these potential witnesses before they give their deposition. And before I'm willing to go out on a limb with that, I'd like to have some authority as to whether or not I can do it. Your motion doesn't cite the authority, so maybe the state will have some in the response. Maybe you'll amend your motion with authority, or I'll go back there and get on Westlaw and do my own research on there.
I was going to say, perhaps, since unbelievably we're actually ahead of schedule on the time you allotted us, that we could take a few minutes during your break.
And I move things along. Go ahead.
Absolutely, and we appreciate it. Maybe we can take a few minutes afterwards and see if we can come up with some more authority. My only concern is that the relief I'm seeking, if it's not immediate, it's not effective. So that's my concern. As to the sealing of it, I just don't think there's a basis for it under our rules. And I think it's more other people's argument than mine.
Okay, well, if the defense would have gone down the hall, downstairs, down the hall to the clerk's office and handed it to them, they would have accepted it. I wouldn't have known it's been filed. Those in the media who look to see what's filed every day would have known that it was there. So based upon that presumption, it will not be sealed. You do have your opportunity to respond. Let's get back to the calendar. Do you want to appear by phone to readdress this issue of the sequestration on Monday morning at 9 a.m. On the 22nd?
Connor, does the court have any time later that week? Later?
I'm trying to coordinate with, on October 30th, I will make the time. I know that next week is a motions hearing time. My only problem is coordinating with the other judge what she has on her schedule. So let me see. On Tuesday the 2nd, that judge is not in this. Oh, that's October. Never mind. Let me go here. On the 30th, it would be the next day that, or October 26th, I can do it in the afternoon at 1:30.
October 26th or the 30th are both preferable to the state.
The defense have any preference as to either one of those days? I could do it any time during the day on the 30th or at 1:30 on the 26th.
If I can just have a second, Your Honor. This is more up to date.
Something to be said for old-time calendars.
I know. I think the 26th works as well as the 22nd. So
Okay, it'll be October 26th. I will just put aside 1 hour. If you need more time, call my judicial assistant and she'll give you the more time. And you may appear by phone. Either side may appear by phone.
We'll appear in person, Your Honor. Would it be at 1:30?
At 1:30. Then let's go into
I'm sorry.
November.
I apologize.
Go ahead.
That's on the motion that we just
Or
filed?
any other motions
Or
that
any
you
other motions
filed
that
that
are
you feel
pending?
need to be heard.
And you will still consider today during your break whether or not to at least impose a temporary restriction on both of us until the 26th. If we can get back to that, is that a possibility?
Let me go through the rest of the
Yes, Your Honor.
stuff, and then that's always a possibility. Let's go into November. Do you want me to set a date? I can do any day between the 6th and the 8th of November. November 12th, the courthouse is closed because it's a holiday, but I don't mind coming in. November 13th, I have all day. November 16th at 9 a.m. November 30th, that takes care of November. Are there any particular days you like in there?
You have to just, well,
November 6th through 8th is a trial docket for me. It's just that Monday that I would have to pick juries, but I don't have to have a trial on any one of those particular days, or I could start the trial at 1:30 or end it at noon for that particular day. That's why I'm offering those days.
you did say Friday, November 16th.
I did.